stated that where a court held, I beg your pardon, yes, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandates. Your Honor, I don't see you writing. I pray it's captured even in your report.
Instantly, I also asked you on the microphone. It's not out of the book. For a reason that you are being captured verbatim.
Most obliged. I hope this except is not expanded. But it says, the court said, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandate. The effect of this decision, and my Lord, Your Honor, I'll furnish court with a copy of the decision. At the rise of court, it's there online. Your Honor, it's online, so you can check it out. It's online. Your Honor, the IT specialist can confirm that there is internet in court right now. Proceed. Most obliged. The judgment emphasized that any action taken by a registrar outside his or her bounds is null and void ab initio. And I already stated that not even an order of court can confer delegated powers. To that note, Your Honor, I appreciate your expressed desire to hear the sureties. I really appreciate. This matter has been adjourned severally, like counsel said. But in the interest of maintaining the integrity and legitimacy of these proceedings, it is in order that the law be followed. I beg your pardon.
I appreciate the express desire that I have, the express desire by the registrar. So I'm not acting under instruction, but I think it's my desire.
Your Honor, if you have, you can borrow me a better word.
The court.
How did we rephrase? I'm trying to think. But I appreciate the express, your availability. I could use the word availability.
It's the court.
You know, I would wish to distinguish the court, the judge, and the court, the registrar. Because that's now where the gist of the discussion is. I say this respectfully, Your Honor. I'm not trying to. I'm just concluding my prayers so that we get into. Yes, like I said, I appreciate the express availability of you, the Honorable Registrar, to receive the particulars of the sureties in this matter. However, in the interest of maintaining the integrity of these proceedings and legitimacy of the application that has been filed by the applicant, it is only in the interest of justice that either the matter is adjourned until the availability of the judge to entertain it, or recourse can be sought from the head of the division or any supervisor to have this matter reallocated and heard by any judicial officer who is available. Otherwise, we shall suffer a fate, the applicant will suffer a fate where several applications will arise to be determined, pending even the determination of his own bail application in regard to the legitimacy of the proceedings. It is the applicant that will suffer. I really want this matter disposed of as quickly as yesterday, but in the right way. In the right way. I so pray, Your Honor. She associates with my submissions. Maybe the clerk can first reiterate what I was saying before counsel stands to the applicant. We do it.
The applicant is duly represented by 6 lawyers. That should not be his worry. Your Worship, first and foremost, I am baffled by submissions of my land council and land state attorney, senior state attorney. Firstly, to note, Your Worship, is that the court is not making a determination in this matter. The court is not sitting to determine the matter. Those are very key, important issues to note. The court has specifically stated that it is here to receive on the sureties for identification as directed by the trial judge. Your Worship, I want the court to note trial judge. The trial judge is every known in this matter. And my land friend has considered every that the trial judge gave directives. Unfortunately, is not here either on health grounds or other grounds, and has issued a directive to that effect. It's unfortunate, it's baffling that my land senior state attorney, who has practiced before this court, cannot appreciate the administrative nature of these courts. Your Worship, the land senior state attorney has stated that section 15 of the TIA enjoins the court to hear bail applications in the High Court by a judge. We do agree that that is the position. However, Your Worship, you're not sitting here. In fact, the courts, as near as possible, have always adopted a procedure under section 14, 2C of the Judicature Act, in as far as section 14, 2C of the Judicature Act. In circumstances where there is no proper procedure and the court is enjoined to promote good.
Can you read the section 2?
Most of it.
think that let's use of the microphone.
That section, Your Worship, is to the effect that where there are no express law or rule is applicable to any matter in issue before the High Court, in conformity with the principles of justice, equity, and good conscience, the court is enjoined to adopt a procedure that aims at promoting equity and good conscience. Your Worship, the directive by the land trial judge is in conformity with this particular provision. And indeed, Your Worship, it has been a practice of this court where the court, under that particular provision of the law, directs the registrars to either identify or receive passports in case a bail application has been concluded, or enforce the directives of the land trial judge. It is in conformity with that particular provision. Your Worship, it is a fortified submission that you're ably in charge of the directive of the land trial judge. You're not sitting as a court to hear a bail application. And indeed, as the land state attorney has stated, section 43(2), equally enjoins this court to give such directives in order to achieve the ends of justice. Your Worship, the land state attorney has relied on the case of Rubble Enterprises to claim that this is a matter where you're sitting as a registrar to hear the matter. We disagree first and foremost. In the Rubble Enterprises case, Your Worship, the registrar entertained certain matters when he did not have jurisdiction. He had determined, and the Supreme Court said, no, you do not have such jurisdiction. This is not a matter where the court is hearing. This is not the matter where the court is saying the sureties are substantial. That is not there. The submissions of my land state attorney should have arisen at the time of an appeal, in case he wants to appeal, that you entertain. Your Worship, it is on that ground that we invite you to proceed and entertain the receipt of the sureties. My land colleague, Mr. has something to say.
May it please Your Worship, I'd like to emphasize section 43(2) and read it in verbatim, that talks about officers of court. And it states as follows.
Section
43(2) of the Judicature Act. 43. That subject to Article 133 of the Constitution, the officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court, and shall be subject to general direction and supervision. And also 43(1) states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the chief registrar, registrars, deputy, etc. Your Worship, when we were here, state can also attest. Just a second.
I just want to clarity. The provision is reading. I want to be sure that we are in sync of the provision. Because the 43 is reading is not the 43 I see in the 7th revised edition. I just wanted to be maybe clarifying that. We seem to be reading different laws.
It's clear here that where in any case no procedure is laid down for High Court by any written law or by practice.
Council, what section are you reading? Because your colleague that wants to ascertain.
Section 43
Of the laws it is.
of the laws it is, Your Worship. And in any case, Your Worship, my learned colleague clearly stated that this court has adopted a practice in applications, and would like to say that you're seated here as court, not in your own capacity or from your own volition. And you stated that immediately you had entered. Your Worship, you clearly stated that you're here to identify. In any case, we already made submissions that you clearly stated were already a record of court. And they associate themselves to those submissions because they have theirs in reply. Meaning, Your Worship, that even a mere giving of date, he will object because you're not, in his opinion, the trial judge. And he would say that that would be a fault-in procedure by his own assertion and submission. In our opinion, Your Worship, you're here in the rightful capacity, and we invite you to perform your duty as assigned to you as court. Most obliged.
Maybe, Your Worship, just one thing, because the land state attorney relied on Bravo Enterprises versus URA. Your Honor, first and foremost, of course, that was equally a civil case, but this court equally is enjoined under Order 51 of the Civil Procedure Rules to entertain interlocutory application. Your Worship, we are not saying you're entertaining an interlocutory application, but this is an interlocutory application that you are equally mandated under Order 51 of the Civil Procedure Rules to entertain. Because this is a bail application arising out of the main case. So, Your Honor,
I don't want you to wait us, just to go elsewhere.
most of them. So, Your Honor, it is our submission that just like how the court gives directives to you to adjourn matters, these directives are in sync with you to receive the sureties as the court has decided. The trial judge has not divested himself of the powers to entertain and determine the application for bail. That one is not anywhere in the court. Secondly, the trial judge has not directed you to determine the substantiality of the witness, of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is a noble duty that everybody should be in the position to appreciate. First and foremost, the documents are already on record. In regards to the sureties, the land state attorney replied to those documents. What is here is specifically to identify the sureties that the court has never had occasion to look at.
Can we have the joint?
Your Worship, if you so wishes, but I don't think that it has them.
Most obliged, Your Honor. I begin with submission that this Honorable Court under Order 51 of the Civil Procedure Act has powers to entertain this application. Your Honor, it was on record. I prayed to make
I said
response.
don't play vote, so it is not going to play vote. So, not someone else.
Well, wait, Your Honor. Your Honor, this matter has been captured on the record.
And it has been captured that is very important in certain establishment.
Your Honor, I don't mind that you don't record
It's okay.
it, but I pray that I still bring it up. Most obliged. My brothers submitted that this Honorable Court by Order 51 of the Civil Procedure Act has the powers to entertain this application.
That's not what he said, but saying interrupted application and he was referring to this interrupted application. Okay?
My Lord, it's actually the same argument.
It is overruled that this court cannot entertain interrupted application on no matters. Proceed. I am going with your objection.
And on that overruling, on that ruling, this is an interlocutory application. A bail application is an interlocutory application. And as court has rightly ruled that it does not have power to entertain, sure, it does not, and I agree with it. My brother has continued to submit that the court, as it sits now, is merely hearing the application, not determining the application. But that's not what is on record. Your Honor, the court is receiving, Your Honor. The record is clear. We can always get a certified copy later, and we shall know what each person said. So my brother has argued that this court is merely hearing, not determining. And he further stated that the court is merely hearing from the sureties who are already on record. How can court determine if in the first place there was no hearing? You know, just the thought of it, it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Mwizerwa, said that I had said, and I wrote it verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. Your Honor, there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits and adjourns the matter, the registrar is not hearing the matter. But when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. Which cannot be tolerated by this honorable court. A section was read, section 14(2)(c). And I would first want to read it verbatim and I make an explanation thereafter. So section 14(2) says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with written law, including any other law in force. Then when we jump to C, where no express law or rule is applicable in any matter, in issue before the High Court, in conformity with the principles of justice, equity, and good conscience. No express law or rule is applicable in a matter, in issue before the High Court. When the law says before the High Court, it is talking about before a judicial officer entertaining, lawfully authorized to entertain the matter. The High Court is not seated here. It's not. We cannot say these proceedings are proceedings of the High Court. They aren't. As far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does good conscience require in the instant case? What does it require? What does justice require? The man is rotting in prison, he needs to come out. But we are not going to illegitimize his application. He needs to come out. And I'm okay with him coming out, but in a proper way.
Concede to that,
So what does justice require? What does equity require? What does good conscience require? In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law, today? That would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizerwa have his day before a judge and have his application determined. No, my lord, I could, you know, counsel, you are not going to divert me. I am responding to section.
It shouldn't be restricted to what we stated.
I'm responding to section 14(2)(c), and that is what was raised.
Your worship, we need some more diamonds.
My brother, please do not distract me. For your record, I cannot be distracted. For your record. Most obliged. And I request my brother, respect some people.
When he raises it up, you take a seat.
And being senior to him, we should really respect him.
And when he stand, you sit down.
So my brother, it's my day. What does the principles of justice require? What do the principles of equity require? What do the principles of good conscience require? Under the instant case, where even the registrar wants to receive particulars of sureties, but cannot go further to hear anything further than that. What is justice? When we are going to adjourn the matter, then when a person who can entertain it comes and you see, think about it. Your Honor, it is my duty as a Minister of Justice to make sure that any illegality, whether it works on my behalf or against my behalf, it is my duty to make sure that it is arrested at the earliest opportune time. And I submit that, Your Honor, the best that this court right now can do is either adjourn this matter till a judicial officer that is authorized appears to handle, or Your Honor, seek supervisory intervention to have this matter reallocated before any other judge today, and we have this matter disposed of today. I retaliate my earlier prayers.
sayidi zombi kafubo ali mu kafubo
start on the American North. American North. A hearing of an application, because the students have already been identified in the pleadings and in the submissions. There is no illegality that is being condoned, which is cleared by the prosecution. The respondent is application. It is a practice that the court has in accordance with section 43 one registers conduct identifications. Now, the role of this court here aims at satisfying court that indeed what was recorded by court under the pleadings, that's the notice of motion and the applicant, and the submissions is what the applicant is presenting. With all the above said, this court proceeds by identification of duties in this application conducted.
Most obliged, Your Honor. Your Honor, I just needed to go on record that I intend to challenge the ruling of this honorable court. I just want that to be on record. Most obliged.
Your Honor, will require a formal by the ruling of the court. by the sureties that were normally the first surety. Mr. Mukasa Yusuf. Mr. Mukasa Yusuf, where are you? Please come forward here.
Abo be balina okweyimirira Hajji bamulaba bajja saagala mugambe nti bagenda muwa bail mukyamuka empola bazze bakubye yunifoomu ya bbulu microphone.
Wengaba nyoluzungu babakkiriza.
Beebo abavuddeyo okweyimirira Hajji naye kubawulira buwulizi si kumuwa.
That's the order.
Yes, that's the order. It's the Mukasa Yusuf as the first surety under paragraph 8 of the affidavit. Your Honor, all the documents in respect of those sureties have been submitted to court.
Counsel, are you watching the...
My Lord, I request that council pass with the correspondence
Your Honor, the documents for Mr. Mukasa Yusuf were submitted.
Oyo ye maamu okuva ku muzikiti e Mutungwe bw'asaalira ate neiba.
We pray that the court identifies Mr. Mukasa Yusuf and takes him as a surety on their behalf. So grateful for the last year. Maybe just to state your Honor, the national ID for the applicant is on record. The LC letter, Kulenga Bill Council 1 is also on record. Your Honor, I would also like the court probably to look at the original national ID of Mr. Mukasa Yusuf, compare with what is on record.
Mr. Mukasa, what is that for now?
Tukira namba yesimu 0772 60 2962. Mr. Mukasa. Applicant is only able to submit on Hajji. He's a friend for 20 years.
okusinga nnyo kuba obusuusu bazirise nawe nkuyitijje ngaayogera omanyi singa wanyita ebiyonda egenda kuba
That is the position you want.
Mukuru Mukasa. Mukasa. Tuteekebwa mugenda nga kkooti nabo ngamba nti gwaawo obagenda. Komawo nokwateka microphone.
omu ayimirira abadde agenze kwetuulira yakooyedde.
So kati gwamaze emabega wasemba naye nga temuvaawo yamaze emabega wamumu emabega erigulu.
The second issue which the court is Mr. Mamen Aristo. The documents in respect to Mr. Mamen Aristo were submitted on record. They have a copy of his national ID, obviously of valid identification. Then the photocopy, that's the original. Mr. Mamen Aristo. Yes,
Boolaba awo be bagenda okweyimirira Hajji naye bali mu kubasunsula nti ono so tekitegeeza nti bamuwadde bbeeyi. Tulinde ruling yaani y'omulamuzi oba Clark aliwo ku lw'omulamuzi.
that is what the record bears.
You have a phone?
I have
What number?
0774 97 18 90.
Any number?
0753 186 720. The permanent residents of Makuga, Randaki, and the vice chairman there. Makuga is on Gono Road, just 12 or around 12 kilometers.
That street is Mr. Mwizerwa. Documents in relation to Mr. Mwizerwa were submitted on issues and also filed on the court. We have a copy of his national ID.
Ekigenda mu maaso kati kwa identifyinga baani abo abeeyimirira Hajji ali be baani era bali mu kuwaabibwakwata kwe baabiwaayo just kwongera confirming nti nze Nurudini Ntege banzaala Arua oba Sudaani omuwawaabirwa omuyita otya, olina ssimu ki, biki ebikwatako, kyekiri mugenda mu maaso kati. Muwala wange omulungi Arsenal bebe onasikia
National ID Okuwukira ndani namba CM 77
ne baddeeshi baabo baseka kuno. Ne baddeeshi baabo nze mbawawaaka naye mo nabo mubalabe, bwemufuna obudde mubalabe.
Secretary LC1. Which place is that?
The worship of the fourth church is Imam Rwanda Siraj, the spiritual leader of the Africa. The worship the documents in respect to Imam Rwanda Siraj, the West African record.
Abo abasatu abakubye yunifoomu ya bbulu bamaze okuwaayo ebyabwe.
Imam Rwanda Siraj. For purposes of comparison and identification.
Long. You have a phone.
Yeah.
Use it. What line is it?
Airtel 072 52
07?
0752 52 82 14.
Rewind. Again.
0752 52 824. Certainly, the telephone number and others, the telephone number for this Hajji is 0752 52 82 then 14. The numbers already been recorded.
Let me hear from Okuwukira. Dad. You are supposed to be charged this week. One. And you go back.
Okukubiriza omusibe okukwatira Mukkooti w'emwagalira okutataganya okumuziyiza okutataganya obujulizi
Can you open one? Where is the dam? Yes. What phone number is
077 077
077 47. Another one 0704 070 80 80 50. Okay.
You repeat the first
it
one?
has not been captured.
Yes.
The first one.
The first one.
0777
077
0 07 777 again.
777
047.
mwongere Saala.
Any other one?
byosabye biri yaabwe letaweddeko
Ye data atandise okuggwako.
tusome enamba
Data agenderera. Enako MB 3.
nazo tezikola
Mukadde wange mulwanya muli. Nsome ku namba ompe ku data.
What are the responsibilities?
obuvunaanyizibwa bw'omuntu eyimenda omuntu bwe buliwo okukkiriza omusigo okujja mu kkooti.
That one has not been said.
Ekyo bakyogedde kati twereeta ansa eyiyungavu singa batasobodde kujja tuddakkiriza kulisalemakuyomusi. But in case the applicant is unable to come and attend, he is eligible to come and inform court why he has not been able to do so. How are you, madam?
What is likely to happen if has not turned up?
Hajji, tuwe ensonga bweki ekikutuukako singa oli aba talabise mu kkooti taze mu kkooti.
Enamba kanji basomere wano mpola mpola, messages zijja nnyingi ate sigenda kugipiininga. Bwe muba ready nga ngisoma.
Kati biri ebintu biri twagala owe ansa singa ekizu kijja nti abuze talabika oba waali naye akujembedde agambye okujja mu kkooti mukwota leeta. Seka, ekyo kkooti ekyagadde nnyo obuvunaanyizibwabwo kati nga gwe omuntu yenna wabanga ateekeddwa okukola ekyagwanidde okukola n'atakikola gwe buvunaanyizibwabwo oteekwa okukwata weebale ansa ntuufu.
But you are going to enter into an agreement with court. That if the defendant does not turn up, you are going to pay.
Enamba kati ngisoma.
Kati kkooti keyagala okutegeeza
Enamba ngisoma. Byensoma by'otayagala bivaako ogende ku live yo. Temutumalaako mirembe.
singa kiba tekisobozezza kkooti ti kyegenda okukola.
Nsoma namba kati
Singa omuntu oli abula n'atalabika
0701
tewali kulonzalonza ensimbi ezo bisasula.
55 85 63
ekibazingiramu mwenna
0701
nti omuntu oyo kkooti singa tetunaba kutegeera
55
naye singa kkooti eba emuwaddeyo
85
mwenna
63
mukaka
y'ennamba eyo.
kkooti ennaku zeebeeteesengawo okulabika mu kkooti wano kujja okikolanga.
Enamba eri 0701 55 85 63 ereeta Nurudini Ntege.
African Council.
Yes, sir.
Upon submission, one submission. And the objection.
Nkuteekako ky'osobola.
An objection to facilities is after this identification, any further objection or submission.
Of the applicant. So I cannot put him.
Kitabo se zisukka mitwalo egi.
I'll teach counsel. It is not at this time that you should make that application. And besides doing that, he has a doubted jurisdiction.
And at any stage of the hearing. So it's asking if wants process. Yeah.
So guys,
All those are the matters for and
So you know that to that point I cannot put in any submissions now until that process is.
so you are seeking for it because
It's not actually a leave, it's a right that I have, yes. It's not a it's a right. On the entire
ayagala kuba tuli mu bano.
Just add a prayer. I pray that the people of court in respect to these proceedings are transcribed and punished to the prosecution because we intend to challenge the ruling and the entire legality of the proceedings.
So guys, tukyali mu kwetegereza abaze okwemerera Hajji.
Your Honor, first and foremost, your jurisdiction has been doubted right from the beginning. So my land colleague is just notifying that you another. So in as regards. I'm just re-emphasizing that now the land is near state attorney, and I believe that this process can be undertaken by the register. On his cross-examination, that should have been indicated at the beginning of the matter before the judge issued the directives.
Muwa ngena mutwala
the objections were made in his submissions.
In respect of the applicant, and even on the jury.
Matter turn to Fifi.
Your Honor, 50th are not available. I'm very sure I'm not available. If it's December,
5th of December.
I prefer convenient date.
Which is the convenient date?
We can get a date next week. Your Honor.
The judge will be coming here.
Your Honor, I have a training which is starting tomorrow. I cannot be available.
Your Honor, but this is our application. This is our application. It's not an application of the state.
But it must be hard.
Sure, but this is our application. You cannot dictate terms of the court. It's like dictating terms without even consulting us. Your Honor, we are available.
You don't know we can make something as seamless without dramatizing.
So, let us.
I said I have a workshop that is starting. We cannot dramatize this. It's part of my professional capacity.
Your Honor, we've been very, very patient with our colleague. On the first day he appeared, we caucused, and he told us that he had a quick training to attend to him. And we did not object to it. We've been very accommodating. And we so wish that he offers that courteousness to this other side. That we've been very patient as always. In any case, he has said he wants to make an application to quickly cross-examine the applicant. What is then that cause for the huge delay? Even when he intimated that he is dying to have the man rotting in prison to quickly come out. Therefore, it's self-defeating that he gives the prominence to a workshop for training, senior as he is, for three days that he cannot carve out one day. When we've been here, Your Honor, we've been here on every single day and even patiently waited. And given collegiality and the seniority of some of us and him,
That's why
we consider him as a senior. But collegiality, let's consider either the 5th, and if he's not available, let him pick out one of the day within this week to say that he can come here and he has his applications honored in the lieu of justice. Please, we request you
find our colleague because we want to move in consensus at the end. Your Honor, I can send someone. Your Honor, I can send someone, but in any case, I'm also always here. For example, next week I'm not available. But we are courteous enough to also delegate people on our side. So if that is his view, in any case, it's not his own responsibility that this case is up to him alone. There are very many people in the staff of the DPP. You can say therefore, I'll delegate another attorney. The other time we had a representative, and we accepted. So we have no problem with you, but delegate someone. Be a good servant of God.
I think my colleague is loud and clear. And in my good servanthood, Your Honor, I am not available this week. I request for a date when I am available, and I am here to handle this matter. I am not a delegate. I cannot delegate. I'm a delegate myself, a delegate of the DPP. And I am handling this matter for and on her behalf in personal conduct. So if the DPP has had me handle this matter, and the same DPP has given me training somewhere else,
Hajji aziddwayo mu kkomera abenda bagamba.
Leero ziri bbiri ku Lwokuna.
Guys, ago masavu ate nga gookya.
Akulidde ebya trip eye Dubai
Kasooka tukumale nze nteka ku kasooka tukumale kyomumanya basawo wakuna weekyana wegugwa
kawedde mudda
notereera kati avayo gweri tuyitoola soka kati
interview zigenda wabweru wa kkooti oli kyokyo wadde kyakugamba